good. All right, guys. Kevin Thompson here, MLM attorney with my good friend Troy Dooley and my associate Clay Brewer. Just spitballing here, talking about the SEC's lawsuit against IX Global. IX Global had a lot of momentum in the industry. They were the talk of the town for about a year. And I had my suspicions because I've been following crypto very closely since 2013, and something just didn't seem quite right. Disclosure here, I'm not typically sympathetic with the SEC. I understand, and I think that their position with crypto is not clear. Their treatment of Ripple, their treatment of Coinbase, that this agency could have done a better job waiting for Congress to pass some guidance and legislation before they jumped in. And another disclosure, when I think a company is being wrongfully treated or wrongfully accused, and Troy, I'll stop talking here. I'll give you the ball here in a second. I'm sorry, but it's just my thoughts on top of my head. I didn't think the FTC was right when they sued Vima, and I defended Vima, and I still think that was a very inappropriate action. I think the FTC's action against Neora was inappropriate, and I hope Neora is victorious. So when I see the government overreaching, I side with the little guy. Here, I'm not surprised at all. And I'm not going to go so far as to say, I hope the SEC wins. This is really painful for the participants involved because IX Global got a lot of people involved, but the SEC's arguments are good and I understand them. And I don't think they're misplaced. I think my last point, people are they're going to wonder, well, what do you think we should do? If you're in this company, the people in IX Global, they're not going to want me to say this, but I don't care. This is a burning building and they're going to want you to stay involved so they can cover their legal fees. And it's hard enough to build a network marketing company, period, with no problems. But now you add on the fact that a company's been sued by the SEC. Good luck. I suggest go build something else because these arguments, the SEC, they can stretch the law. They can stretch their view of the law. Like what is a security? Let's see how it applies to the Howey test. They usually don't stretch the facts. And they've got some pretty damning facts in this complaint that, in my opinion, there's a problem. Now, there's a lot to discuss here. Troy, what's on top of your mind here?
Well, one is that they're going after, if I read the complaint right, and this is where you two have got to come in and correct me if I'm wrong, but in the complaint, the fraud portion of this isn't against IX Global, it's against DebtBox and the founders of DebtBox. They're saying that company, everything they've purported is false. There's no pumping oil, there's no scanning device, stuff like that. So if they lose on that, if DebtBox is able to prove out all of this stuff, where does that leave IX Global? Do they still are they still facing the unregistered securities part of this, or would the SEC shut the case down if they're presenting it based on the fraudulent activity of DebtBox?
Yeah. I've never seen a piecemeal approach like this where they have one sort of treatment for these parties, but then a different treatment for these parties. They're being very careful here. There were allegations of fraud with DebtBox, and I think that stems to the SEC's allegation that DebtBox is issuing tokens that they say are backed by assets that aren't really backed by assets. And if these tokens are not backed by assets, that's fraud. That's the F word. That's one of the worst possible offenses you can make when you're in the security landscape. The IX Global, they're saying that IX Global was selling unregistered securities. So DebtBox is issuing these securities, and IX Global, their business was in selling these securities,
which is the software license, correct? I mean, in reality, and then the SEC saying no, that's not a software license, that's an investment.
Well, it's one and the same, tomato.
Okay. Yeah. Okay.
And
investment contract. Yeah.
Now it's an investment contract. What does this? So IX Global right now is under an injunction meaning the SEC rushed into courtroom and they said, hey, this is an emergency, Your Honor. We need a relief right now. And they got it, and which is pretty standard. And my experience with the SEC, typically they do investigate by sending a subpoena to the company. The company can prepare and they kind of know it's coming.
Well, Kevin, let me say on that.
They blindsided the company.
Yeah, but IX Global's still in business. Their websites are still up. They're still going, but Xbox has been taken over by the receiver.
That's right. So IX Global's not, okay. So the injunction says nobody can sell securities.
Right.
It does not say that IX Global cannot operate, cannot sell other products. And so it looks like that's what IX Global is trying to pivot to and say, hey, we're going to sell other things. Everything's fine. My point is, it's not fine. And if I were in the field, and I know my friends in this business, they don't want me to say this, but just being really candid, I'd get the hell out, because this is a very, very serious legal dispute. It's going to be very expensive. It's going to hang over this company's head forever. And I don't think, candidly, I don't think IX Global is going to survive this thing.
Okay, let me ask a question on that. I did listen to a call that Joe Martinez did. Now, he is the founder of IX Global last night, and he was very clear on that call. People that have tokens from the Xbox, if they want to sell those tokens, go ahead and sell them. They want to hold them. That company, when I studied that company, Kevin, and you guys can help me here, they're an education company. I'm still a little bit confused on how the debt box got involved. It's nowhere on their website. They're kind of like an iMarkets Live. That's the only company I can think of in our industry right now where it's just an education-based company. And that's what these guys look like. So with that being said, if fraud is brought in by the debt box company and they were presenting that wrongly to Joe Martinez, his guys, do they then have a leg to say, wait, on behalf of all of our members, we want to countersue, or how would something work like that, since they're the ones out there marketing for these guys?
They could claim ignorance, and they could claim that they're victims of this deal. It's going to be a nasty legal dispute where I think, but with what little I know here, full disclosure, if I were quarterbacking this situation, everybody needs to get separate counsel. And that way, because I don't think every single defendant is in the same boat. I think Debtbox might have known some things. I think IX Global knew some things. I think the field knew some things, and they all knew different things. And so I think it's preferable for everybody to get separate lawyers, and you're going to have people lobbing missiles at each other at some point. They're not doing it yet, right? IX Global saying, hey, we love Debtbox. They're great. That tune might change. You mentioned iMarkets Live. They're under an FTC investigation. It's literally on the FTC's website. So that's not a great example. But you're right. It is possible to sell financial education. I want to go to the underlying product and forget this line between Debtbox and IX Global. Okay. This idea of software licenses. And give me a minute here. You know, I think slow, and I like to talk it out. The evolution of crypto in our industry is companies created their own coin. Clearly, it was a Ponzi scheme, and the more people bought it, the more it went up in value. Ponzi scheme. That was OneCoin's model. Now, interestingly enough, OneCoin, they didn't really sell their own token. They sold mining tokens. They said, hey, you buy the mining tokens, those mining tokens, they mine the other token. There's a little similarity here. But that's old school MLM crypto. Then you had concepts of cloud mining. So Bitcoin mining is perfectly legal. Bitcoin's not a security. And these companies said, hey, look, Mr. Dooley, you don't know how to mine Bitcoin. We do. You give us $10,000. We run the machines for you. We'll give you a share. It seems very simple. SEC says that's an investment contract. And so what I'm seeing and here with this software mining, I'm still wrapping my head around this. Like Clay and I, we've been hearing about this for months. We've had multiple clients say, IX Global's doing it. Why can't we? And to Clay's credit, who did the hard research, we were very adamant in saying it doesn't matter. It's stupid. It's too close to the line, and layered with an MLM model, this is doomsday. And some listened. That's the value of good counsel. Software licenses. Let's follow this for a little bit. So they're saying it's decentralized. That's the crypto and cryptocurrency. Crypto is cryptography, open. Bitcoin, anybody can mine with some technical skills. Ether, I stake Ethereum. I run a node. I run a validators. Anybody can do it, open source. Here you're saying, well, it's decentralized, but you have to buy the software through this company. I don't understand that. That to me screams centralization. There's an entity here running this thing. It's not really open. Now that could maybe just being dumb about how this works, but it doesn't feel right. Back to the point. That's the evolution of crypto in the industry. You see all these different models come out, but what is an investment? What is a security, right? The SEC, they have this thing called a Howey test. It's a Supreme Court case, literally from the 40s. It clearly is dated, but it's their standard. And they put it out in their complaint, and I'll put it out here for the viewers. It's an investment of money, any kind of investment, in a common enterprise. So that's where centralization is a thing. It's a money pooled where somebody manages those assets and does something with it. And there's an expectation of profit. So people put in X and they expect to pull out Y. All right. So a share of Apple stock, obviously a security. I can't control what they do with the iPhone. It's a passive investment security. Here, the allegations are pretty, in my opinion, pretty damn clear that that even IX Global, debt box IX Global, I don't know where one ends and the other begins, but representations were made. Hey, we're digging for oil. We're digging for natural gas. And when you buy these tokens, you get some yield from this effort. It just seems, and they're saying, well, these tokens aren't securities. Well, in the Howey case, it was oranges. It was an orange grove. Oranges aren't securities. It was the whole structure. So I don't care about the token itself. There's centrality here. There's a promise where, hey, we're doing good work here. We're doing this satellite thing. We're doing this natural gas thing. And when you buy our software, we release tokens through this platform and you get a piece. Last point, and I'm done. It's a question of mine is that if and the IX Global people probably say I'm an idiot for even asking this, but if I have a token that represents natural gas, a commodity, that token crashed after the lawsuit, right? So the market doesn't think there's a connection between these tokens and these commodities, right? The market doesn't think there's a connection there. So that means, are these tokens really tied to real things? It just doesn't look like it is. And even if it is, my original point remains, this is all a central enterprise here promising passive returns. I think these guys are in a lot of trouble.
Okay, with what you said, and obviously we have a depository where we're looking at stuff that came from the lawsuit and stuff that's in public, so we're eyeballing this. You've brought up some great questions that, and I want to be able to ask questions for the layperson that may not understand it all. Let's start backwards and move forwards. The token crashed, but it's since recovered, not to its height, but there's obvious buying and selling of all of these tokens on an exchange. So there, does that help the longer story? Does that help the fact that not everybody's now selling? Some people are starting to buy back to show, hey, the token's got value. We still got to question the underlying assets, but does that help the defendants, or does it matter?
It might matter. So, the real-time feedback is good. There's a guy, John Brannon, say that we're wrong, Troy. It says the royalties from the projects buys tokens. You don't share profits. Whatever that means, the fact is a business is doing something and the token holders are benefiting. That's the point. And if that's happening, there's your security. Now, whether there's underlying assets or not, that goes to fraud. To answer your question, does the fact that these tokens have value, does that help? I don't think it helps. I think ultimately, in my opinion, how I explain it to clients, it really, instead of making this too complicated, and sometimes entrepreneurs can outsmart themselves.
Sure.
They see 3 elements in the Howey test and they really try to analytically approach each one. If it ultimately boils down to that 3rd element, the expectation of profit. And if there's any sort of speculation at all about the value of these tokens, then the SEC is not going to have a hard time showing that the whole program was designed to play into that speculative nature, that people weren't buying products, they were investing, right? I can go to my brokerage account and buy an ETF for
Sure.
natural gas, right? That's a regulated product. So here I don't think it helps or hurts that these things still have value. If anything, it shows that the market believes that there's an underlying asset behind it. That's interesting, but I still think it doesn't disprove the security problem.
Okay. Does the fact and in digging into this, we have 2, it seems like, because now people are saying we're wrong. So I want to say it seems to me as if we have 2 different pieces of the puzzle at BLOX. We have the software license, but now there's also hardware that's involved. So if they're selling the software license, it goes with hardware that creates the token. And I want to use that word because this is on the Binance. So there's no mining on the Binance blockchain. You create these. That it does seem like there's a limited amount of tokens that the BLOX founders have created that they disperse out through the software. There's also a limited amount of licenses for the master software license. So a lot of these guys, there was like 30,000 licenses. And then after that, there's all these sub licenses and probably it's like BTC or anything else. Everybody's playing.
They're trying to create scarcity to create value for the licenses.
I think so. I mean, that definitely looked like it. The fact that there's hardware and software that's involved here, does that help, hurt? Did the SEC, would they have taken that into account that, hey, we actually have hardware too, so they're buying hardware for the software? Does that matter?
I still think there's a central entity here making these decisions, controlling, juicing the value. There was a lot of allegations about promises made, meaning things that are coming. Hey, we have a license with this beverage entity, and as that deal generates value, that value then flows to the token holders. So we still have the problem with Howey. I keep getting comments, royalties buy up tokens. So that's to me is damning evidence that this company has set up a program to control the price of these tokens, to create scarcity for these tokens.
And the biggest,
well, one more point, Clay. People talk about, well, is it legal to buy Bitcoin mining stuff? Of course it's legal. Buy it, run it. You're not pooling your money in a common enterprise. Nobody is taking your money, managing it for you, buying the mining machines for you, running them for you, and distributing the proceeds for you. So that is not a relevant analogy. Same with Ethereum. You incur the cost, and it's open source, and anybody can do it. Here, because it's all centrally controlled, they got a serious problem. Clay, what were you going to say?
yeah, and the biggest issue, to kind of dive deeper into Troy's question of software versus hardware, just reading the SEC's complaint on its face, they're saying that nothing was happening. So sure, you can have hardware lying in a garage, for example, and you can download software, but their premise of the whole complaint was that nothing was even happening, nothing was being mined. And so, for example, you have these 11 categories of whatever commodity, oil, gas, et cetera, is being conducted, but they're not, these royalties or whatever you want to call it, aren't being conducted by mining operations. They're just kind of poofed out of thin air to hypothetically represent something that the company's arguing that exists. And so that's the real core issue, not the actual hardware, software presence or not. Because I don't doubt that it's present. It's just, what are they doing?
Right. The token is the token exists. They create it, as Clay said, and then through this process, they release those tokens to the miners. So they're in, yeah, they're in control. There might be a day in the future where we have tokenized assets, meaning you can, some third party audits an oil field and certifies certain tokens before they're released. It seems like that's what these guys are trying to do here, but it's so early, and you have just you have this network marketing mindset, which is chasing yield. I mean, some of the defendants, I've seen their posts for over a year talking about, hey, look at these staking returns. It's great to be in this business. You mine for these various things, and money just shows up in your wallet. The way it was promoted like an investment. Even in the press release yesterday, these guys issued a statement. Let me see if I can find it. Yeah, here it is. Let's see here. We are very clear in our disclaimers on every call, every Zoom, that getting involved in crypto is unregulated and risky. Actually, it's not unregulated. Never risk more than you can afford to lose. Well, that language right there, first of all, did a lawyer even look at this? That language implies, it doesn't say the I word, it doesn't say invest, but that's language that you typically see with investments. Never invest more than you can afford to lose. So I think it's pretty obvious that's the whole point of this thing. And when you have, there's two sacred fields in America. One is healthcare. When it comes to the treatment of diseases, there's a process for that. Another is finance. When you're giving people financial advice, man, it's dangerous.
Well, it's very, very dangerous. I want to look at a couple things. And if people wonder why I'm hitting on this, it's because I know these are questions that we've already gotten coming in, and there's people in the field that are still confused. And I think if we can bring it into layman's terms, it's going to help everybody. So let's back up for a minute. And when I look at the initial complaint, one of the things that the SEC really hones into, and we've been using this term ourselves here, is mining. And I used create because there is a difference here. And there isn't, all of these licenses cannot just create. There has to be a system, which is probably where the software comes into play. But as you said, Kevin, there is a centralized location. Somebody is creating the master tokens, and then however they get distributed or however that works, that's just going to work. Could this company had launched the way they've launched, could it just be premature? There's rumor out there that they are building their own blockchain that will be decentralized. They had already started to move into the AUE. Is there a possibility that they just did this all backwards and it's a legitimate business model? Is there, because you've got history, I've got history in crypto, Clay's got history. Is there any validity to it that you can see that maybe they just jumped the gun and all this wording that they're using is going to work for a different blockchain?
I'm having a hard time answering that. I think their existing model runs afoul of the law, period. And they're trying to pivot to the UAE. Fine, but they're doing it really late because they've already extracted a lot of money out of the US market, which triggers the SEC, which triggers US law. So if they had done the UAE thing first and geofenced American participants, could there be a way for them to have done this? Maybe. Maybe. I still think you got a problem. But I can't speak to UAE law, but I think you're placing and I forget the issue with their own blockchain. The let's call them the investors, the buyers, they're placing a lot of trust in an entity to secure all these relationships with whoever, gold mining, resource mining, natural gas. They're still trusting somebody somewhere to execute. And so you're going to have, even if you don't run afoul of SEC rules, let's say they're in another country, I'd be suspicious. I would probably, I wouldn't buy the tokens. I just buy a damn ETF, right? If I really wanted commodity exposure.
Makes sense. That makes sense. So let's look at that. Let's look at that angle for a minute. The lawsuit says it's a $50 million scheme, which we've all been involved in schemes that That's kind of pocket change when you look at how much money some of these schemes have been. When I look at the elaborate, if this is a scheme, the net from this seems very, very low, because you would have had to have had not just all the multiple players that they've listed as co-defendants, but you've got to have, you've got to spend money on actors that are going to be at these oil wells pretending that they're actual oil riggers. You've got all these guys that went to Ghana and some of these other places and in these villages and these government officials. Do you honestly think that's all a scam? I mean, some of our friends actually were in this company. They traveled over here. Can that all be a sham? I mean, how elaborate does somebody go for a few bucks? I mean, off of a $50 million quote unquote scheme.
I agree. Usually your massive frauds, they generate more money.
Yeah.
Like Omega Pro, and yeah, they soak up a ton of money. That's why my immediate reaction is, I don't think this is a case of a Ponzi scheme. I don't think it's a case of fraud. I think it's very clearly a case of violating civil SEC rules. I just think this fits squarely inside the Howey test, and it always has ever since the day I first saw it, right? There's an entity somewhere making moves, influencing the value of these tokens. And when you look at Bitcoin, that doesn't exist. Correct. Ethereum, there's arguments that, oh, the Ethereum Foundation does things to juice the value. But token distribution is so vast, and it's anybody can stake, and there's a voting process. But here, that's not the case at all. This thing is very closely held. So if I were in the field, I'm out. I don't want to ride this out. I'm going to build something that's a bit easier to build. And by all means, be a retail buyer and buy a software license, whatever. But I wouldn't promote the damn thing and get other people to buy, because now you're selling unregistered securities. You're not just a victim, you're a perpetrator. Now, IX Global, the TRO currently says you can't sell securities. So IX Global, they're going to pivot and say, well, we're going to sell information. Good luck, right? I mean, our industry is littered with dead bodies of people doing Forex training.
Well, and honestly, I believe that was the way their website has been the whole time. It seems to me that once you become a member, then you had some private opportunities to do some of this other stuff. And let me ask you a question, because you and I have had this discussion many times, even before Clay came onto the firm. We had the Jobs Act back in 16 or 14 or something, and that's where crowdfunding really got split. And there's more accredited investing rules that you have to abide by. And I'd sent you guys a client not too long ago overseas. It was a gaming client looking to do some stuff in America. When I look at these licenses, they go from it seems like $1,000 up to $11,000. There's different times at different places. In the Jobs Act, even if these guys came out clean in every other area, there could be an area there where they were taking money more than $2,500. And I've not seen anywhere where people had to do anything to prove their accreditation as an investor. So can that be another area that this is again, not done intentionally, but they could have screwed this thing up? Because I don't think they have an attorney. I mean, they might say they have an attorney. I know a lot of attorneys, and I don't know one that would have let them do some of the stuff that they've done without really looking at this.
Oh, for sure. Yeah. I mean, none of my competitors would have greenlit this thing. Now, we give advice all the time and people don't listen. Doesn't mean the legal counsel's bad. So we don't know what information they have. You mentioned the Jobs Act. The only thing I know is that in order to take advantage of that law and raise money from non-accredited investors, it has to run through a portal, a registered portal like Kickstarter. So I don't know if that's really relevant here. Another issue that hasn't been alleged but could, I mean, this thing could mushroom cloud into more. If these guys fight really hard, I think the SEC has a lot more bullets they can fire. One is pyramid scheme. Are we dealing with a pyramid scheme? And Clay, you dug into their pay plan. What'd you find?
I mean, the biggest thing is, like Troy said, their website of IX Global is still live. So, I mean, whenever you education, subscriptions, whatever you want to call it, whenever you force someone to purchase that subscription monthly for the right to sell and market those products. That's textbook pyramiding. And
So
that's
yeah,
what
so
we're trying to
go
do.
backwards. What did you see? Do you see a requirement to buy?
Yes, it's blatantly in their marketing materials. You have to buy a subscription and monthly maintain that subscription in order to be a brand ambassador. And then it kind of promotes you to do the same thing. Find 3 people who buy a subscription that's best for them. And that kind of has everyone naturally enrolling by purchasing the subscription.
Is could I didn't look at that. Could that be an MVR where they say you can buy or sell a pack, or are you
I didn't, it's very possible, but I didn't read it that way or see it that way.
Yeah,
But
pyramid scheme.
again, it all comes down to how they operate in practice. And again, this could be kind of the first arrow in the SEC's quiver to get underneath the hood of further issues that might be out there. I'm sure you can't sell securities now, but what else are you doing? Oh, we see X, Y, and Z. Let's explore further, kind of thing.
Okay, on that note, and that goes back to the beginning of our interview here, but also of the complaint. You have a group of individuals in this complaint that they've hit with fraud straight across the board. It's just fraud. Then you've got a group of individuals that they're saying, because we believe that this is fraud and because we are alleging that it's a registered or an unregistered security, we're going to hit you for selling an unregistered security.
Mhm.
So going to an old adage, the chicken or the egg, in a lawsuit like this, will they try to go after the non-fraud people first because that's easier to go after, or will they have to prove there was fraud, including in order for them to move the case forward?
No, they don't have to prove
Okay.
fraud as a condition to the other thing. I think at a minimum, they have to prove a security.
Mhm.
And I think, in my opinion, that's just clear. And so the people that were selling that, whether they knew it or not, and we had a lot of Zeke people in this situation
Sure.
where they were promoting this thing that the receiver alleged, and they didn't know, but they said, hey, you were selling unregistered securities. And so they had to pay. And their penalty, the penalty was really driven by their level of knowledge. So if I'm advising a distributor in this situation, I'm like, don't try to fight this thing. Just hat in hand. You didn't know, you made a mistake, give them the information they want, and then negotiate the penalty amount.
Okay. Now
That's the cheapest way to get to the other side of this thing, because if you, I think you could litigate for years and ultimately you're going to lose.
okay, let's look at something on that. And you brought up Zeke, which I'm very familiar with Zeke. Zeke had nothing. It was a reverse auction. There was nothing. Here we have software and possibly hardware. So an individual in IX Global could actually have 2 hats. I'm a victim because I actually bought all this stuff believing that it was legit. And then I marketed it because I saw the returns. I don't know another word to use in this case. So I saw profits. I saw this thing working. Does that put them? How does the SEC look at this? Am I a victim? I mean, obviously, in some of these cases, one of our dear friends, they've nailed his assets. I mean, his stuff is frozen, but yet they're calling him a promoter. But I know for a fact he bought software licenses and hardware. How does the SEC look at a person with 2 hats on like that?
I think they have more sympathy, because you're right. Zeke was a very sophisticated fraud.
Yeah.
And, one could argue that participants should have known that they were pushing something that didn't really have any value. Like, were they really using, in that case, penny auction bids?
Right. Here,
it's a plausible, it's crypto is so confusing that I think a participant can very easily claim ignorance and not have the book thrown at them. I still think you've got disgorgement of profits. So whatever money was made turns over. I think the net winners in this case, they're going to have to pay, even if they've been sued or not. I think obviously we know how this works, right? So just to inform the people watching, the receiver takes control of the enterprise, And then at some point they have to go and make the pool of money as large as possible so they can pay back the victims, what they call the victims, people who lost money in this thing. And they do that by going after the net winners, like Bernie Madoff. People who made money with Bernie Madoff, they had to pay it back. People who made money in Zeke had to pay it back. We represented quite a bit of the Zeke net winners. And the game there is you try to negotiate a lesser amount. But that day is coming. That day is coming.
Kevin, in using Zeke again as our example, and we can move forward into, we could use one coin, it doesn't matter. Looking at the difference there, where it was all internal, there was no retail sale of tokens like we have here. How does a person that just went out there, saw these tokens, heard the story, thought, hey man, maybe these tokens are going to go up, I'm going to go buy the gas, the oil, the gold, the scan, the beverage, if they just bought tokens, are they just out of luck, or would they be able to hit the receiver's website and say, I'm holding this many tokens and I'd like to be classified a net loser because I put in 10,000, I've only got 5,000. Is there do they have any recourse there themselves?
The people that just bought the tokens?
Yeah, just a retail investor of the tokens.
Yeah, there would be a claim. It's called a claims process.
Okay.
And so the receiver will have a website and they'll request information. And that website, I'm assuming it'll hit in the next few months.
It's already up. They've already, it's debt box receiver. They already snagged it, popped it, and it's up.
Yeah, that's the start. But the claims process, where they solicit information from the public,
Gotcha. Yeah,
that's going to hit. And then that's where, if I'm a retail investor, absolutely. Yeah, I put my information in there, and then you wait in line. And then the receiver, of course, is going to eat off of this carcass. It's expensive, so they're going to get paid, but they'll bring in more than they spend, and then they'll do distributions.
Okay, now let just bring me up. I mean, my mind's flowing now. Knowing that we've seen some of the SEC's activity when it comes to the exchanges in the United States, specifically Binance, because this is built on a fork from Binance, but also on Coinbase. Could the exchanges where these tokens are at, can they be held responsible then as well for selling an unregistered security?
Absolutely. Yeah. Coinbase was sued for selling unregistered securities.
Sure.
They are being sued. They're in active litigation. What's a token? Solana, which is a widely used token. I don't think it's a security. I'm a Solana holder.
I have some. Yep.
Yeah, but the SEC says that's a security, and sure, yes, the exchanges can absolutely, and they will be brought in. I don't know where these tokens, what exchange is listing these tokens? There is a market somewhere. I looked it up. There's value.
There's a market. There were several exchanges where these are at, and I don't think it's in the complaint. It's on the Binance blockchain. So I'm also going to assume some of these could have been on Binance, and we know Binance is being sued as well by the SEC. Could that have played a part in this as well, or would this investigation been long going prior to the Binance investigation?
I don't know. BNB is open source. So, that does not mean that Binance, the entity, participated in the scheme. There's a lot of crappy programs on BNB. So I don't know if there's a connection.
Okay. Well, I just want to, and I know some of these may sound elementary to you guys, but I'm asking them because I know already I've got people that are uneducated that got into this. I was on the phone with a dynamic network marketing leader yesterday, and he said, Troy, I didn't know anything about crypto. This just looked really good. And I liked the hard assets. And honestly, I believe that's where a lot of people were. It was the hard assets that caused people to get involved, because they could actually see oil rigs. They could see people talking to tribal leaders. So I think all that played into this. But in a case like this, where this is so far out there, is what type of time does it take for the SEC to take this to court, get the injunction? I'm assuming now that the defendants will have some lawyers that can come in and try to get an emergency relief so that they can get their company back. How does the process work, guys?
So we've seen this movie before. It's currently under a receivership, or debt box is. IX Global is not. So they've got a short period of time to appear to challenge this TRO. And I think I heard something like 10 days. That's pretty standard. 10 days, 2 weeks, let's say. And I really don't think they're going to be successful in getting this injunction lifted. And so assuming the injunction stays in place, debt box is over, right? So the receiver has control of that thing. You have what's called a preliminary injunction hearing a month or two later, which it just, if they lose if debt box loses the TRO, usually what happens is they then agree. They say, we don't need to go to the preliminary injunction hearing. Let's just agree to these basic things. And then the receiver takes over, and and then the litigation progresses. Then you get into discovery, and then the SEC is massively thorough. And their track record with crypto is they're almost undefeated. They were issued sort of their first defeat in the Ripple case regarding whether Ripple was or XRP was a security.
Right. It was
that was after $100 million in legal fees in 2 years.
Yeah.
So IX Global will probably be allowed to continue as a network marketing business and do something.
Mhm.
I just I mean, talk about a cloud over a company's head. It's not going to be good.
Yeah. Because the biggest issue there too is I know that the debt box materials don't necessarily show the link to IX Global, but I did find, and the complaint kind of says it as well, when you try to sign up on Debtbox's website, the URL at the very top, it kind of has like an IX Global link to it, sort of. So it's kind of like you're going through their system indirectly to get to the licenses. And so the SEC's position is that everyone had to buy a subscription and become a brand ambassador in order to purchase these licenses. Whether true or not, I have no idea. That's just what they're stating. And so that could be a big issue for the company. How many of these people bought this solely to get to the licenses and the quote unquote harder assets? That could be a very difficult thing to unravel in the event it's true. If it's not, it could be an easier separation, move forward. But if a lot of these subscriptions were made just for access to something else, that's another can of worms that might open up quickly.
All right, and Clay, I know you've downloaded the documents for us to continue. There's like 1,000 different things you've downloaded. One of the things I noticed in the initial complaint, there's a lot of conversation about the beverage company, Lazy Magnolia Beverage, it's local by me. It's down here in Mississippi, but it's not in the complaint. They just talk about it a lot. Now, could there be other entities that these guys own, don't own, that are part of this that may or may not come into it later? Could the beverage company be brought into it if somehow, you know, they weren't producing any type of bottling activities, stuff like that? I mean, it seems like the SEC jumped the gun a little bit, because in their complaint, they allege a lot, and I haven't looked at all the supporting documents, but I can't tell where this is all at. I just keep going back to my layman's mindset of it's only $50 million. The trader's domain is like massive. And it's like, I look at this and it's like, why did they jump the gun instead of letting this mushroom like we know they have done in the past?
I think there's a clear answer to that. And before I get there, people are saying you can buy the product without being a rep. Okay, let's assume that's true.
Yeah.
Let's assume that's true. Are the customer numbers good to where it's not a pyramid scheme? I doubt it. And Troy, I am going to answer that, but also you mentioned how it's a very sophisticated message where it's pretty easy to believe, right? It makes sense. Clay and I have been on Zooms with very gifted lawyers talking about this concept.
Okay.
And my point has always been, yeah, but there's an element of speculation here. At some point, there's a token, and I know network marketers, and they're going to speculate, and they're going to talk, and they're going to talk about ROI. That's going to drive the program. So you can't get around that. To answer your question, the SEC, it does seem like they jumped the gun when they saw money moving overseas. They saw efforts being taken in specific statements from, I don't know if it was DebtBox or IX Global, regarding
did-
Abu
I did
Dhabi.
see that. Yeah, I haven't been
Yeah.
able to find that statement publicly. Maybe it's out there, but yes, I did see that in the complaint.
Yeah. So they I think they saw money moving. I think it was like less than $1 million.
Yeah, 750,000.
They, at that point, they can't wait. And they also saw some other thing being discussed that really reeked of being a security, meaning somehow the token value was tied to the output of certain businesses. And so they jumped in. As they learn, they can modify their lawsuit. And so if these other entities like that beverage company you mentioned, if they participated in the scheme, and I doubt it, they're probably in discussions. But if they participated, then they'll absolutely get roped in later.
Okay.
So I can speak on that a bit more. So I think the SEC jumped the gun here. I don't think they jumped the gun. And the reason is because, obviously everything in the complaint is not true until the SEC proves it. They have the burden. So say that at the outset. But on June 14th, on YouTube, DebtBox came out and said that they would be moved, like Abu Dhabi, the Emiratis, does not have jurisdiction over the SEC, first of all. And then on June 26th of this year, IX Global closed their bank accounts to move. It seems that's their allegations. So that's probably why they wanted to get this ready to rock and roll and kind of then maybe learn more before everyone kind of left the US shores. And that's the biggest issue of why they did that. And then secondly, when it comes to Lazy Magnolia, so it seems like the individual Jason Anderson, who marketed himself as being the owner and founder of DebtBox, also owns Lazy Magnolia. So that might be an interesting connection. They were promoting that they had all these contracts with these third parties. Again, they may not, but that's really the core issue. And so it looks like the SEC is saying, we have no proof that any of this exists, and so we're going to allege that it's all false. In the event they are true, it doesn't necessarily remove the unregistered securities aspects, though. Just because there's a real product does not mean that it's not a security. So there's still another hurdle to overcome. And again, the SEC has to prove that. They have the burden, not the defendants. But that could kind of be the angle that they're going. And you bring this case now to get it in court, to get all these asset freezes done before it switches names, before it's overseas. And
That point
by UAE aspects are very different when it comes to crypto. So a lot of companies think that they go there, think OneCoin, for example, that you can't be touched. It's a misconception, but it looks like that's what may have been happening here from the SEC's perspective.
Let's talk about that, guys, because I literally, I bet I've had 7 or 8 US citizens this year say, look, we've moved our assets, our crypto assets. We're going to build our business from there. We're launching our business from there. If you're a US citizen and you're soliciting US citizens, no matter where your business is located, are you not still governed by US law?
100%. Yeah. There's no free pass for operating in the UAE. The moment you talk to an American participant and get American dollars, SEC jurisdiction kicks in. And Clay mentioned that it doesn't matter if the underlying assets is security or not. Go back to the Howie case, right? Again, we're dealing with oranges. And so whether these tokens that are attached to these assets are really tied to assets, that goes to the F word, fraud. But and the comments here on this thread, people seem to forget you still have a central enterprise coordinating all of this.
Yeah.
And that's the problem. Hey, we will take your money, give you this software license that you can use to mine these tokens that basically we create. And the value is largely predicated on the company's ability to execute. That's the problem. And so and then people say, well, the DebtBox thing was a small part of the business. I don't believe that. All the promotions that I saw, it was about these tokens. Actually, I've never seen a single promotion about training. But so let's say IX Global is going to pivot and try to do something else and sell education. You still have pending SEC litigation. You still have a company under an anvil from the SEC. I just don't think it's worth building, candidly. You need to choose intelligent leaders that you trust. In network marketing, money isn't the most valuable currency. Mel Atwood makes this point. It's relationships. And are you going to leverage your relationships and bring them into a company that's dealing with an SEC lawsuit? Are you going to do that? I don't think it's a good idea.
It's a tough one. I've had a client that just finished up. It was almost a 7-year case with the SEC, unregistered security, which you and I had that discussion. And from day one, unregistered security, that was not in question. They brought fraud, they brought Ponzi scheme, they brought pyramid. At the end, after 6 years, and I want people to understand, I'm not going to name the company, but this is what happened. The judge gave a summary judgment and said unregistered security, bar none, down. This is how it was marketed. This is the way it was. My client felt like he won because he didn't get fraud, he didn't get Ponzi, and he didn't get pyramid. The average person couldn't have done what he did. It cost him $50 million in lawyers' fees and fines to get a win of unregistered security. So no matter how, I don't know how much money was there. I'm telling you, if there's only 50 million, the guys are going to settle this case out. They're not going to fight. They're going to try to keep something in their bank account if they can. And unregistered security, I agree with you, Kevin, on this. After looking at it, that's going to be that probably will be what happens. I don't know about the rest of it. Maybe there's fraud, maybe there's not. But no matter how you look at the ecosystem, I believe that they're going to be able to claim that unregistered security. And that's a civil penalty. That's not a criminal penalty, if I'm correct. That's a civil. Okay. And people still can lose their assets, though, at least what might have been won or earned from selling that unregistered security.
Agreed, 100%. And DebtBox or IX Global, they can sue their lawyer. All right, if they had counsel somewhere that said, "Hey, yeah, it's fine," then they could do a reliance on counsel defense. I don't think they have that. I can't imagine Clay or I giving a green light here. And we don't do corporate securities work. We know enough about crypto and MLM to know the Howey test. We spent
that a step further. The Howey test is for Ponzi schemes. Let's talk about cost.
It's for securities.
Yeah.
Securities.
So let's look at the pyramid scheme that can be alleged here as well. And let's talk about the Cosket, Burn Lounge, even Fortune High Tech. Let's talk about what we've started to see from that side of it when they try to claim the pyramid side.
Well, so to rehash the rule, pyramiding is when you pay rewards unrelated to product sales. So suppose we sell a $10,000 energy drink, not really a product. So courts then want to see customer sales. Who's buying the thing that's not attached to the program? Ultimately, that's what pyramid scheme law comes down to. Burn Lounge, it was 3% of the revenue came from customers, right? So yeah, let's say we're dealing with a legit product, that the software license is not a security, that it truly is decentralized, which good luck with that argument, but let's just assume that they can prove that it's decentralized, even though they're controlling everything. Let's just assume it's a legit product. Now they got to prove, although it wasn't alleged in the complaint, but if the SEC has some difficulty in litigation, they're going to add that allegation. All right, it's a pyramid scheme. It's false and misleading. It violates the FTC
still
Act.
out there too. They can jump in if they want to.
FTC can jump in. And so now DebtBox has to prove customer sales. They have to prove the structure of their pay plan led to good behaviors. They have to prove compliance. I've got a close friend who does outside compliance, and he's telling me that DebtBox, doesn't have anybody that does compliance. Now they probably do. They got somebody somewhere. But who is monitoring the field? Who is disciplining the field? Where's that record of discipline? That's all relevant if the pyramid scheme allegation comes in. And I'm not even confident DebtBox could survive that, or I'm sorry, IX Global could survive.
Yeah, I was going to say that wouldn't even be on DebtBox. That'd be on IX Global because they're the marketing arm for
right.
the DebtBox.
It's also important to know that just because a product has a value does not immediately alleviate pyramid concerns either. You have to have genuine bona fide customers who aren't within the opportunity, because I can think that this highlighter has great value, but if only people that are buying it are people that are trying to market the opportunity, then a pyramid exists. And that's the biggest misconception.
Well,
Yeah.
didn't we
out
just
there.
learn that in the Nolan case? That, I mean, Clay
Right.
covered it pretty good.
That's how I read it. Yeah. And then so to go back to a comment that was made earlier about how you don't have to be, or people that aren't brand ambassadors can purchase the product. Well, to become a brand ambassador, do you have to purchase the product? And then you can disperse the numbers where, okay, just because there's an option, is there really a presence there? And so that's the biggest thing of why record keeping is so important on that avenue.
Well, and let's look at the Neora case. My opinion, a good company, 70% retail.
Yeah.
And they've had a hard time dealing with those allegations. And you're dealing with a product that with a 12-month refund policy. Here we're dealing with software licenses for mining crypto. Man, good luck.
Yeah, that was a tough one. We're seeing after Herbalife, Vima, Advocare, we're starting to see now where the companies are saying, look, we know customers are very, very important. And I've got some clients we've shifted to Amazon. They're still doing network marketing, just so everybody, we sell the product at retail plus 10%, but they're able to show, look, there's value without a network for our product. They're building a customer base, but it's still the network. If the FTC comes in and looks at the network and it's all network and there's no customers in the network, well, you still got a pyramid division over here that's it's only buying because they were making a commission. And that's the frustrating part, is that even the comments here, people think as the messengers, as we trying to discuss this in a way that people understand, that somehow we're haters. And that's not the case. What we're trying to do, and you and I have had this stance from day one, crypto and MLM to date doesn't mix. I've not seen any capable way of mixing the two. And I think every example has ended up upside down. I don't know one yet that's not upside down.
Agreed.
Yeah.
So,
Yeah, agreed. It's unfortunate for the participants in the program. And this is why I don't go full blast when I see these companies. I do on occasion. I didn't with IX Global, but when you put your neck out there, then you have all these participants start stalking you and just saying, you're an idiot, you're jealous, you don't have the facts. The reality is we've been in this business long enough to know it just ain't going to work. And then this wasn't that hard for me to discern. I saw the motivation. People were talking about ROI, plain and simple. Buy a natural gas token, right? It's clean energy and it's going to be valuable. Or buy this BEV token tied to these beverage deals. And so, in my opinion, if there's even the slightest possibility of speculation of the product, the SEC is not going to have a hard time cracking that nut. They're not going to let this program continue, because the SEC has an interest to control the flow of capital. They don't want people dumping hundreds of thousands of dollars in pointless schemes. That's a misallocation of capital. That's bad for the economy. So yeah, they got involved. And as we've discussed here, they've got a lot of bullets to this gun. They've got the fraud bullet, which I think we all agree that I think fraud is unlikely. I don't think these people are that dumb. And you're right, it's very elaborate.
Yeah, I can't picture that part of it.
You have to be very particular with fraud. It's a high pleading element. So it's a tough thing as a lawyer to plead for. So you have to have specifics. But I think it's very important too that, I mean, if anyone ever says that they got the thumbs up from regulators, SEC, FTC, whatever, just run in the opposite direction of that, because regulators never give a thumbs up in the United States for anything in this regard. So never listen to
that was a lie.
Then secondly, you want to, I know it's tough in this situation because they thought that they did, and it could be true. Again, I'm not sure, but you want to verify that what they're selling is actually there, or what they're operating is actually there. Otherwise, you get into a OneCoin situation where they had the greatest blockchain that ever existed until it didn't, right? That's a huge issue. And when you get into these aspects, it's difficult to maybe verify everything, but You should never have a promoter that says, I don't know how it works, but here's an app. That's an issue, you know?
Yeah. Well, you mentioned there was a statement where a guy says, we talked to the SEC and they gave us a thumbs up and said, quote, keep doing what you're doing. They don't do that.
No, at all.
No. And so the right way to do this, it never would have gotten off the ground, but the right way to do it would have been to get a no action letter. You can present your plan to the SEC. This is what we want to do. And the SEC, in some cases, will come back and give you what's called a no action letter. Based on what you're presenting to us, we don't think this violates securities regulation. They didn't do that here. Now, if they had submitted an app for a no action letter, they wouldn't have gotten a response. The SEC would not have blessed this with a network marketing model. Never would have happened.
Let's talk about that for a minute, Kevin, because I've sent you at least one client that we were trying to get a no action letter. These aren't cheap either, from the legal side or from filing and all that. Explain a little bit so that people understand you can't just put a letter in or hit a website at the SEC and you're going to be able to submit this.
I mean, you're looking at our firm. We've submitted apps. We have a corporate securities lawyer, and it's roughly $15,000 to $20,000. You go to a big Washington D.C. firm, it'll be a lot more. But if this is as powerful a company as they were promoting or presenting themselves, that shouldn't have been a cost prohibitive thing. And again, the reason why they didn't do it, they knew they would never get the letter, so they launched, hoping that they just. I don't know. They would project a certain model that the SEC wouldn't find offensive. But I didn't see a lot of discipline in the field. I saw the promotions.
No, there wasn't a lot of discipline. I think one of the other things I saw is that somebody claimed the SEC audited the debt box. Now, whether they mean that is the hardware, or whether they mean the company, the SEC doesn't audit companies either. But take that a little bit different direction. Let's talk about Coinbase as an example, because Coinbase went through the process to become a publicly traded company, was stamped, and later the SEC has sued them. So just because somebody came in and said, yes, you're okay today, doesn't mean they're not going to sue you tomorrow anyway, correct?
100%. Right. Absolutely. Yeah. And the podcasts I've listened to with SEC Commissioner, her name is Hirsch. I forget her first name. She's Crypto Mom. Clay is who it's Hester Pierce. That's it. Hester Pierce.
Hester Pierce. Yeah. She's a co-commissioner. Yeah.
Yeah. She's Crypto Mom, and but she says, even if you get a letter, it all depends. And that's Coinbase's main complaint now, is that you have one presidential or one president with a certain commissioner. They greenlit Coinbase. Now you have a new president with a new commissioner, and he sued him. Troy, I'm agreeing with you. Just because you get the stamp, and we're not dealing with a stamp here, but even if you get one, doesn't mean you're out of the woods.
So let me pivot just a second, keeping to what we're doing. But this is the second big case that seems to have come from the Utah office. We've got Trader's Domain that's also out of there. I think that also is tied with the CFTC. But I want to look at something in these two cases. Could this be that office is taking a very active stance because of the MLM side of things? Is that a possibility?
It could be. It could be because there's a lot of perpetrators in that market. I think when it comes to network marketing with traditional companies, you really can't find better operators than what you have in Utah. They're world class. Yeah. Right. They have it dialed in when it comes to health and wellness, obviously. But then it sparks out, well, the creative sorts where they're like, well, crypto is exciting and we have this network marketing understanding. So you're seeing some examples where it's coming out of Utah. I wasn't thinking of Trader's Domain. I was thinking of Green United. That came out of Utah. Didn't it, Clay? I'm pretty sure it did. Where
I'm looking at it right now. Let's see.
It's Utah. And that
yes, Utah
specifically dealt with software licenses. The same thing, where there's and the allegation there is that and it was Thurston Wright and a few other people were selling software licenses for people to run nodes to do this token. And in my opinion, when you get new information from the market, you really can't play dumb anymore. And if I'm IX Global and I saw that lawsuit hit 4 months ago, I'm getting the hell out of that space. I'm not trying to move to Abu Dhabi with the concept. I'm done with the concept.
Now on
in the
that
network.
note,
Yeah.
do they put the dots together? Because let's go to Green International for a minute. There's people that were there at corporate that are now in other companies that are either marketing some kind of banking card or they're marketing crypto and all that. If they get on the radar, do they monitor these guys?
Oh,
See
yeah.
what, and they go boom, hit them again?
Absolutely. Yeah, they're human beings.
Yeah.
And I've had conversations with enforcement lawyers that are familiar with certain personalities, and they follow them.
Okay,
Right.
and that's important. I knew that, but I want people to understand that sometimes it's the actors. And in this lawsuit, there's some people listed in here that are secondary, but they're listed here as people that have sold databases to some of these guys. They'd already been in trouble in the SEC in a couple of cases. And I know for a fact they've already launched new companies that are questionable. And it's like, okay, you got to do your due diligence. It's not that we want to squash anybody's dreams. We've all made money in network marketing. That's why we're still here. That's why we still do what we do. But you got to do it right, or it's all for naught, because it doesn't matter how much money you're making if they're going to take it back anyway because you're in a company that didn't make it right.
In order to start a bank, you've got to get an FDIC license, and they investigate the board. And the people on that board have to have impeccable credentials. I'm not saying we need to have the same standard here, but when you're in the field, and again, the most valuable asset somebody has is their relationships. If you're going to leverage your network, it's really important to know that the people running the business have an unblemished record. Because at some point, you just can't play dumb anymore. All right, let's say somebody participated in Omega Pro. Oh, I didn't know. Okay, fine. You get one free bite of the apple. But then the same people heavily promote and participate in Trader's Domain. Same people. At some point, you're either lying or you're stupid. It's one or the other, right? You're lying in that you didn't know, or you're dumb because, right, there's birds of a feather flock together, and there's a pattern there. And so I think it's really important to vet the people behind the organization. I don't know who's behind IX Global. Troy, you dug deeper there. I think there is a history with some issues. Like somebody said the CEO was arrested in Mexico. I don't know what that means. Maybe it's true. Apparently there's a connection with Kuvera. They had an issue with the CFTC, right? That's relevant.
It's just interesting. The more I look at this, the more I look at some others, and some of these turn into criminal. Richard Angeloni, who's passed away, but the company that he was with and they were doing, those guys that's all criminal. They all went for tax evasion. They fraud. I mean, I'm going through some of the videos of that right now to really see what went wrong. How do you go from a civil case to a criminal case with people spending long terms in prison, and it's supposed to be an MLM? So, I mean, there's times when you don't know what's going on, and you can have somebody that you think's the greatest person under the sun, and they don't know either. I mean, it's another one of those, the blind leading the blind, because they're believing someone. And these guys, again, this could be no fraud. And I still have a hard time believing that there's intentional fraud in this thing. I just think they didn't get the right legal advice, or they didn't take the right legal advice is more apt. Both companies launched at different times, and they came together and did this thing, and that's fine. But if you're joining a company like Kevin's saying, even some of our clients we get frustrated with because they don't listen. But you need to make sure you're doing it right, because even what's the FTC now? They're going after individuals, and they just go after a Young Living. 3 people in Young Living had to pay 5 figures in fines for saying something that wasn't right. They're not just going after the companies now; they're going after the individual.
Yeah, and there's 3 ambassadors as co-defendants in this case, so it's not out of the ordinary.
What's the difference, Clay, between I noticed in here defendant and relief defendants? What's the difference in those terms?
Sure. So defendants are the ones that are actually involved in the scheme or whatever the complaint says. Relief defendants is how you would get like monies back. So let's say that I own company A and I did a bad thing. I may own companies B and C that has assets that I can kind of go for. So you name all these relief. So in the event this person goes, I don't know, bankrupt, for example, and there's a lot of issues there, of course, but you can then reach to those assets to get some kind of money instead of them just saying, oh, sorry, fine me for unregistered securities, but I have no money.
That's how they got Orbison to settle in Fortune High Tech. He was in a pretty good position. We were actually part of that case, and they threatened to sue his kids. And the relief defendant, it just means that money flowed there. Like, okay, so your wife, you might not have the money, but your wife has it. You transferred the money to her, so she's a relief party. Relief defendants, it doesn't mean that they're going to be liable for the fraud part, but they might have to cough up the money.
The money back. Okay, so I've noticed in here, let's talk about this for a second. And man, I appreciate you guys' time, but let's look at this. So we've got individuals who then own or control LLCs and these companies. So the individual goes bankrupt, let's just say. So then they're still going to say, well, it's in the LLC. They can break that corporate shield. Not necessarily is it really two entities. They're going to try to prove it's just one.
They could.
You can pierce that corporate veil, is what you call in the legal sphere, in the event that you disperse those funds to avoid a judgment or something. That's illegal. You can't take funds that you've earned from fraud, or not fraud, but you know what I mean, just for lack of a better term right now, from fraudulent company A to hide it in B and say, oh, sorry, A doesn't have any money, kind of thing. You got it illegally, so we're going to find a way to get it, because that the statutes aren't made for that protection.
Yeah, the regulators have a lot of power here, and they freeze real estate holdings, and they're going to get their pound of flesh.
Right. So, for example, in the complaint, it'll say like LLC X received $4.7 million in investor funds to which it had no legitimate claim. So that company had no ties to why they got these funds, but someone who owned that company funneled it there and hoping they can save it for a rainy day.
That makes sense. I got one in here. This is an off the wall one, but I'll let's say there's no fraud at all. This is all legit. This individual is asking, could this be the U.S. government's way of getting the technology, because this technology is so advanced? I'm not sure I saw any advanced technology, but what's your input on that?
I don't even know what to say. It's maybe the SEC sees a pattern, just like they did with cloud mining. Cloud mining was a thing, and now it's not a thing anymore, where people took money from investors and said, hey, we'll mine for you. And that's not a fraudulent thing. Now, that there was some fraud where they were actually claiming to be mining and they weren't. That's fraud. But the SEC sued a couple of those companies, and that creates a lot of clarity in the market regarding that concept. And so that makes my job easier as a lawyer, telling people, you can't do this because of this outcome. So this idea of software licenses running nodes, it's new. And this could be the SEC's way of creating clarity. And this is what they do. They regulate through enforcement. They could be seeing a pattern, and this is their way of saying, this is what's going to happen if you sell software licenses for nodes. If you do this thing, you can't play dumb anymore. So that could be behind it.
Okay, I'm going to ask one last question, and I'm going to let you guys tie up any loose ends that you've got. Looking at the concept minus the network marketing piece, could you see that there's validity to creating an ecosystem like this, where there's tokens that are being fueled, the blockchain's being fueled off of these natural resources, off of making something work like this? Is this tangible?
I think it's going to happen at some point, for sure. It's called real world assets. And maybe there's a way where some third party entity validates the assets, the gold being mined, and then the coins are created based on that. And those coins are then tied to real things. There's a question of, is it still a security? Because there's centralization in this deal. Yeah. I envision a world where you can buy these things through like Fidelity, right? You can buy tokens of gold tokens backed by gold
Correct.
at Fidelity, at a brokerage firm, a regulated institution. But moving these tokens or moving these mining machines through a network marketing company where the business is really at risk of what distributors say, it's massively irresponsible, massively. And Troy, we're gonna get so much shit.
There's no doubt.
They're gonna say, oh, they the company. I want to make it clear they have an interest to keep everybody in the burning building, right? They need to keep this thing alive so they can fund litigation. They're gonna say we're just full of shit. That's fine. That's their right. I think they got serious problems, and we'll be proven right probably in the next 6 months.
Well, I want to see how this plays out, because I've got dear friends that I don't want to see have a problem. But I was always intrigued with the debt box side of this. I could care less about the MLM side, but when I looked at real hardcore assets and somehow this working, it's like, man, this is as good as energy credits. And I think someday energy credits are gonna be a big thing. So
carbon credits, absolutely.
Yeah, absolutely. I mean, it just the way it's going to be. I don't think it mixes with MLM, but I definitely think that there's something here right now. But let me ask one. I thought I had the last question, but let me ask this. If they'd have set it up as a DAO, would that have helped them, being we're all decentralized now and this is how we're working, or would we still have had that basic, the SEC has mandate over this?
Clay, you did a lot of research on DAOs.
Yeah,
we've had
there's
this
still
question.
be serious issues. Although like Tennessee, for example, Wyoming, for example, recognize DAOs as being a legal entity now similar to an LLC. There's been a recent case called Uki DAO out of California. And that case said that there was so much centralization still, despite the DAO name, that every token holder was considered to be liable for those damages. So that could be an issue. So
okay.
in
So
short,
not a terrible idea, but
I like
really,
that idea,
really,
just not yet.
really hard to pull off.
Right.
Well, and I brought that up because I do want people to understand, and look, they put blinders on, that Thompson Burton just isn't an MLM law firm. You guys actually dig in, your client base is large. You've got all these attorneys that handle all these different pieces of business. You guys just happen to specialize in the direct sales side of this thing, but you know crypto very well.
Well, thanks for the plug.
Yeah.
We I'll send you a coffee mug.
Yeah, I appreciate that. Yeah.
We've got 40 lawyers and we do a lot of stuff. We do a lot of litigation. We do a lot of distributor litigation with the company and also on behalf of distributors. So we've been around, let's say, just not as long as you, Troy, but we've seen some stuff. And
but it's a different interview, but we've had some fun together over
we
had a blast, man.
Yeah, we've seen this movie before.
Yeah, we would have been there in the beginning. We really.
I was talking with my partner Walt Burton. We did a hangout back then. It was called Hangouts with Walt Burton and you,
yes,
and our bankruptcy lawyer when Zeke Rewards melted down.
Yep, that's. It's been a while. It's been a while.
Yeah,
you know, but it's been fun. Any closing thoughts, gentlemen?
Clay, what about you?
I just think that it's huge that I hear it all the time from company executives that, oh, well, company X is doing it. I think that this should be example A of it doesn't matter. Debt could have easily been green and green could be in the situation, right? So if this just shows the benefits of good counsel, that you keep your ear to the ground and you see the ripple effects of certain cases. You should have seen this coming from a mile away. Regardless of how much you believe in the validity of a product or an opportunity or whatever it might be, regulators could disagree. I have plenty of disagreements with regulators, but you have to follow the laws and the tea leaves and how they're played out. So.
Yeah. I would just caution the field not to have cognitive dissonance, not to believe everything they're fed, because the company has an interest of keeping everybody together so the revenue stream is protected. Just to the people that have been sued, the shortest way out of this is to settle with the SEC and pay. I just don't see a massive litigation effort yielding success at the other end of this. That's my opinion. So yeah,
you just said something there that I want to bring up too. After Zeke Rewards, I think some of the others, we've seen proponents of legal defense funds. And I'm telling you, don't go down that rabbit trail either. Don't give your money to somebody else. If you want an attorney, get an attorney, but don't think you're going to defend the company. Don't try to defend the concept. Try to defend yourself. If you need to defend yourself in this. How long we're going to continue, guys, to cover this case, Kevin, usually, and Clay, how long before we see something fresh come out of the court? Is the next move on the defendant's side of this thing?
We'll see something. This TRO hearing is happening in I think 10 days.
Okay.
We'll know more there. The company can challenge it and try to get this receivership out of there and try to get the injunction lifted. The injunction only says you can't sell securities. So that they're not going to win that. They're not supposed to be selling securities.
Right.
So the injunction is pretty limited. They might actually agree to it. And then just,
they could still get their assets back if they can somehow in this time period prove we're legit, we've got this stuff. Then could they unfreeze their asset, let them get money to pay their attorneys, or how does something like that work?
Usually they have to ask permission for groceries.
Oh,
right? It's very detailed financial records they have to show, and then money can be unfrozen for very specific reasons. So that's I highly doubt that a court would unfreeze the assets. They could unfreeze it as part of a settlement, like we saw with VEMA, right? The SEC or the FTC agreed to unfreeze certain things. They did force Borrego to sell his golf cart. That was really,
I noticed that. Yeah,
that was funny. So it's a street fight, but we will know more in 10 days. The SEC is not going to talk. IX Global, they're going to talk a lot to keep this thing together. So a lot of communication is going to come out of that company and saying everything's fine. We're ready. Everything's fine. Everything's fine. You'll learn a lot after that TRO hearing.
Yeah, because I have noticed DebtBox hasn't said anything. Those guys have actually been silent, which I think they probably have some, if they've got legal counsel. Rumor is they've got a New York law firm, 17 attorneys working on this. If that's true, they've already been told, keep your mouth shut. If anything's going to be said, it's going to come from our office or our publicist. It's not going to come from you. So
right. Well, they're dealing with the fraud allegation. It's very serious. That's DOJ stuff. That's very serious.
That's a big one there. So, man, you guys have been great. We get something new out of this. I know Clay's monitoring this. We'll get back on here and we'll do some more.
That sounds awesome. All right. Take care, guys.
It's really always fun, guys.